Very much, and good morning, everybody. I was sitting at the back there. What a great presentation on great work that the professor's doing. I thought, how do I follow something like that? So, in the term of Monty Python, now for something completely different. In my world of finance, particularly superannuation is a topic that I focus on an awful lot. With people dealing with their own superannuation arrangements called self-managed super funds. If people want to borrow through their superannuation funds, they take out what is called a limited recourse borrowing arrangement. We know that as LRBA. So when the professor was talking about LRBA, I thought there was a slight connection there. But as it turns out, alas, that was the extent of it. I think, or people think, superannuation is complex, but it is nothing compared to what the likes of the professor and the medical specialists and everybody do. We do an awful lot of work with medical specialists, and I'm always amazed at the complexity of what they do. So to me, superannuation is straightforward, nothing like what the professor does. I'm from Perpetual, as Carol indicated, and we are one of Australia's largest managers of charitable wealth. There's many aspects to Perpetual. But we have been around for 130 years, starting off as a trust company, and we manage people's wealth. We have an investment division, we have a Perpetual Private or an advice division, and we have a corporate trust division as well. So that's a very little bit of background on Perpetual. But what I'm talking to you today about is estate planning and charitable giving. And most people in the room, I'm sure, will have their estate planning in order. So in some ways, this morning might just be a little refresher. And we always say that it's important to keep your estate planning affairs up to date. So even though you might have things in order, it's always appropriate to review your estate planning arrangements just to make sure they're up to date and are directed in the way you want. In terms of ways of giving, though, I'll just kick off to start with. Of course, most of us will know about the ways of direct giving. I mean, people that it's the most common. It's the one-off sort of donations that we make. We have many street appeals that you see. If we went down Martin Place today, I'm sure we'd be approached by many people from different charities and organisations wanting money and so forth. But these are sort of spontaneous one-off type donations, whereas there is a way of giving in a more formal or structured way, structured giving. And what structured giving is about is the giving of money or property through a trust, a charitable trust. Now, I don't want to get too complicated, but the advantages of doing this, of course, is that it's a more, as I said, structured arrangement that makes a lasting difference. It's not just that one-off donation. There is a lasting difference to what you're doing when you organise your affairs through an endowment or a trust arrangement. You have more control and you are far more involved in the activity of giving, and you leave a lasting legacy, something that Carol just also mentioned before. It also provides for future generations to play a role in the opportunity to provide through a trust as well. And a big thing, of course, is it's tax effective, which means that not only through donations that you might make that you get a tax benefit. Of course, if the income and the capital growth of investments through trusts and so forth is tax-free, there's more that can be spent on the good work that is being done. So being tax effective is critical, but it means there's more funds available to do research and other things that is appropriate. Look, I won't go through the options other than just briefly to say that, you know, there is a way of setting up a private, what we call a private ancillary fund. That's where, you know, you actually have total control of a charitable arrangement that you not only provide funds to charities and foundation work and so forth. It's a way of having a complete control. There are public ways of doing it and doing that through management accounts, so you can have involvement through that way. I'll just skip through those. But just choosing the right structure in terms of what is best for you, it depends on your objectives and what you want to achieve and your level of involvement and control that you want. I mean, if you want full control and you want to take on the responsibility of the accounting, the audit, the compliance work, or do you want to hand that over to somebody else and just have an endowment and then direct where you want to give the money, you can do that. But what I wanted to talk to you this morning about was making sure that your estate planning affairs are in order. It is critical, of course, because you want your money, your assets to go to the beneficiaries, the charities of where you want them to be directed, and you want to make sure it's right. So what is estate planning? A lot of people think estate planning is just having a will, but it's far more than just having a will. So it's not just about what happens to your assets when you pass away, it's also who takes charge of your affairs while you're alive if you lose capacity. We call that your backup plan. What happens, if you lose capacity, unable to manage your own affairs, certainly you haven't passed away, but somebody needs to manage what is going on. So we call that your backup plan. I'm not going to go through each element of an estate plan, but I just want to highlight how complex it can be. As I said, it's not just about having a will, and an awful lot of Australians, we know an awful lot of Australians don't have a will, and that causes complications because if you die without a will, you die intestate. And the way in which your assets are distributed are through what is called a statutory order. And of course, it may end up in the right hands, wrong hands, whatever the case might be, but the issue is take control, have a will, you direct where your estate assets should be going to rather than dying intestate, and leaving many of your loved ones distressed about are they going to end up with the money from your estate or charities, etc., what the next might be. There's a whole host of things, testamentary trusts, superannuation I'll touch slightly on as well. People who run businesses need to worry about succession planning with that. When we see blended families, for example, we are now seeing more prevalent life interests in assets where you might have husband and wife, a second wife and so forth, but children from the first marriage. But you certainly want to care for your current spouse, and you might leave them entitlement to live in the home until they pass away and then the assets revert back. So things like life interests are becoming far more prevalent. Charitable giving is a critical part of estate planning to make sure that you're bequesting your assets, cash to, or particularly assets to charities and foundations so they can do the good work that they are doing. And then of course there's powers of attorney, which is very critical when we talk about incapacity going forward. So when you're looking at estate planning, just at a very high level, basic level, you need to spend time thinking about who should be responsible for your affairs in the event that you lose capacity. And we know with an ageing population and an increasing incidence of dementia that this is becoming more and more important, that regardless of age, people really should have a power of attorney for somebody to take over their affairs should something happen to them, like a car accident, end up in a coma, who looks after their affairs, even if the people are very young. So it's a case of think about who would be responsible for your affairs in the event that you lose capacity. In terms of estate planning, who would you like your estate assets to go to? Who do you want to leave your assets, your money to in the event of death? Conversely, who do you not like your estate assets to go to on the other side of the equation? But be very careful, we're seeing a lot more incidents of the family provision arrangements coming into play that, as I was saying, like we want to know who we want to leave our money to, who we don't want to leave our money to, but there can be disputes over wills, and I'm sure you're very familiar with situations where if you want to exclude somebody from your will, you've got to be careful that isn't subjecting your estate to a challenge after you pass away. So in some ways, have you made adequate provision for somebody who thinks that they can put their hand up and say, well, I should have been entitled to part of that estate? The classic one we saw earlier this year was the Mead-Lemon case. And I'm not sure if you're familiar with this, but this was a big one in WA where Olivia Mead, who was the 19-year-old daughter of Michael Wright. Michael Wright's father was Lang Hancock's partner over in WA. And so Michael Wright passed away, leaving an estate of about $1 billion. And he had 3 children, one being Olivia Mead, but she was from another relationship. And so he left his 2 other children, $400 million each, and he left Olivia Mead $3 million in a trust that was quite restrictive. So she challenged that and claimed that she should be entitled to something in the order of about $13 million. And the court actually awarded her $25 million, basically, and not through a trust, it was left directly to her. The issue was, of course, you can see, Michael Wright had really excluded her from his estate. But the thing is, though, the issue is what is adequate provision? So The point I'm trying to make here is that courts have the power to vary your will if you do not make adequate provision for the proper maintenance, education and advancement in life of certain persons. So, you know, have a genuine reason why you don't want to leave money to somebody, and maybe even stipulate that. But just be mindful it might be better to leave some form of provision for somebody to avoid, you know, the will being contested at a later date. Nevertheless, your lawyers will certainly be able to help you in that aspect of it. And then, of course, part of this process of estate planning is to identify the owners of your most valuable assets, what you own, because there's different ways of holding assets, I'm sure you appreciate, and it will depend on whether your assets actually form part of your estate in the first place. Your estate is what you deal with through your will, but not everything you own may be dealt with through your will, and I'll come to that in a moment. So clarity in writing bequests into will, there's some practical issues that are quite important that, you know, if you're wanting money to be left to the Garvan and so forth, you know, you've got to make sure that everything is covered off properly in your will. You ensure the correct wording for a bequest. You certainly don't want to have an incorrect legal name because that can cause problems later on. I do believe, though, the Garvan has the wording should you be interested in leaving a bequest through your will, so it makes sure it goes to the party that you want to do that. Also, if you're leaving a bequest for a specific purpose, be conscious of not stipulating conditions for the use of funds that may be at odds with the way in which they may be used. Now, that wouldn't necessarily be the case here, but I did see a potential client's will only a matter of 2 or 3 months ago where in this lady's case, she'd stipulated she wanted to leave money to charities and so forth, but the conditions that she was applying on it was saying the CEO can't earn more than $200,000, and I want my accountant to order the charity's accounts and so forth. And of course, the charity will just put the hand up and say, not interested, I'm sure. So, you know, you don't want to put too onerous conditions into a will that it makes the bequest, you know, inappropriate. So just be mindful of that. So it's important to review your estate planning, including your will regularly. So as I said earlier, even if you've got your estate planning in order, it is still appropriate to look at it on a regular basis to ensure that it is up to date. So when I talk about identifying what assets are left through your estate, for example, there are assets what are called estate assets, and these are the assets that are dealt with your will, and there are other assets that are called non-estate assets that aren't dealt with through your will and will pass in any event. Now, estate assets are things that are owned in your own name. They're assets that are owned as tenants in common. There's business interests and so forth, and assets specifically directed to your estate. Non-estate assets, I think, are more important to identify what's not going to be dealt with in your will, through your will, are things that's assets that are owned jointly. So the family home, for example, is often owned as joint tenants, which means in the event of death, your share in the home automatically goes to the surviving spouse. That isn't dealt with through your estate. You don't write that into your will. It's a jointly owned asset. It automatically passes on death. Superannuation is another one. Super is, much to many people's surprise, is a non-estate asset. It isn't dealt with through your will. It automatically gets paid from a fund to a beneficiary unless you specifically direct it to your estate and then deal with it through your will. Life insurance, interest in a discretionary trust, for example. So trust structures aren't necessarily dealt with through your will. So typically, a person's largest assets are their home and their super, and the home, being owned jointly with the spouse, is a non-estate asset. And as I mentioned earlier, superannuation is also a non-estate asset, meaning it doesn't get dealt with through your will unless you specifically direct your super to your estate. So, your estate plan. The objectives when you put together a estate plan is to pass control and ownership of all your assets, estate assets that is, and interests effectively to the people you want it to go to. You want to maximise asset protection. You want to ensure that the assets that pass to your beneficiaries, the assets are protected so they don't then go out the door to some other person through a relationship breakdown, for example. We obviously want to try and minimise tax. We want to make bequests and so forth in a most tax-effective manner, because what it means is that more ends up in the hands of your beneficiary and nominated charities, such as the Garvan. You know, you want to have them to have more money to work with than being taxed inappropriately along the way. And also to consider the impact on government benefits of beneficiaries. All too often we see a client that has inherited some money and they're most concerned that they're going to lose the age pension because they've now got... So the thing is, you know, maybe it is appropriate to receive the money, but you know, you've got to ensure that depending on how important government benefits are to beneficiaries, that you direct your estate assets in the most appropriate manner. In terms of while alive, appoint attorneys, have an enduring power of attorney in the case of incapacity that I talked about. And then of course, estate planning includes healthcare wishes and end-of-life preferences as well. It is all part of the estate planning package. But about minimising tax, I'm not going to be too technical on tax here, but I just want to highlight here that capital gains tax. Capital gains tax is a tax that applies on an asset that you buy at one value that increases to another value that is not your home, for example. And say you have an investment property or you have shares or managed funds and you buy for $1,000 and they go up to $10,000, that gain will be taxed. So the point I'm making here is that death is not a CGT event. It's not a capital gains tax event. It passes to the next generation. It's only on the final disposal or sale of an asset that CGT arises, not the event of death itself. So that's why it's important when you're looking at estate planning that the records of your investment assets, the cost base and purchase price is essential to be bequeathed to your beneficiaries so they know their tax position. It's all well and good to say, I will leave my BHP shares to my son and leave him no records, you know, because he doesn't know what to do with them in terms of a tax position when it comes time to sell them. CGT may also apply, capital gains tax may apply when any other assets are sold. There are exceptions for the family home. The family home that passes to the surviving spouse, all well and good, but ultimately when they pass away and the house passes into their estate and to the next generation, no capital gains tax is paid in that 2-year window between date of death and the end of 2 years. So if the house is dealt with and sold in that period of time, there's no capital gains tax event. Go 2 years and 1 day, then any growth in the value of the home from the date of death is taxed. So there's a 2-year window opportunity, unless of course you have a beneficiary, maybe a son or a daughter that continues to live in the home as their principal place of residence, then CGT won't apply. But otherwise, if it's going to be sold, the suggestion is, and this is not advice, I can't give advice, maybe you want to do that in the 2-year period. Other assets that you hold, other investment assets, will depend on whether you acquired those assets before or after September 85, when capital gains tax was introduced. Because effectively, and most people nowadays have assets acquired after September 85, again, those assets are already what we call in the capital gains tax net. When they pass to the next generation, then of course no capital gains tax applies, as I said earlier, as on death, it'll pass through to when they ultimately sell their assets and so forth. It's important now when you are looking at leaving assets to charities, the Garvan and so forth, that if you are leaving assets to what is technically called a deductible gift recipient, sorry about the term, the DGR, and if they're in an endorsed DGR charity, which the Garvan is, then there will be no capital gains tax paid on any assets you leave them. And that's important because that means it's more money for the Garvan to use. The unfortunate thing would be is if you see an estate sell an asset, pay capital gains tax and then pay the net proceeds to a foundation or the charity, there's less money for them to work with. So in some ways, when you are bequeathing assets to what is called a deductible gift recipient endorsed charity, then we can avoid capital gains tax on that transfer of assets and so forth. So it is important to consider the tax implications on proposed bequests. I just want to briefly talk on testamentary trusts because these are becoming more and more popular when we're dealing with asset protection, minimising tax. That's what a testamentary trust. I think the best thing to do is run through a simple example. I think a lot of people can relate to this. Say we have John and Jenny and they have 2 children, David and Karen. They have wills that leave their estate to each other and then to their children, David and Karen, in equal shares. So if something happens to John and Jenny, their estates, well, if something happened to John, it'll first go to Jenny, and then if something happens to Jenny, then it'll go in equal proportions to David and Karen. Karen is married to Jim, and they have two children, Max 5 and Jane 2. It's all well and good. So John and Jenny pass away and 50% goes to Karen. So 50% of John and Jenny's estate end up in Karen's hands. But unfortunately, something happens to Karen, so now Jim has control. And Jim repartners, marries Mary, and they have a child, Beth. So you can possibly see that this could end in tears in terms of what was originally John and Jenny's assets walking out the door to Mary and potentially Beth, when it possibly should have been Karen and the children Max and Jane. So what can be done to overcome this is the use of a testamentary trust. We talk about asset protection. The money still goes to the people that need it most, but we put a trust structure. We don't leave it directly in this case. So what we do is we appoint Karen as trustee, a testamentary trust. She is a beneficiary with her two children. And it allows for the flexibility of distribution of income to them. There are tax savings, especially when you've got minor children, because minor children who receive income through an estate receive the same adult tax rates, including the tax-free threshold of $18,000, rather than the penalty tax that normally applies for children when you go above $416. So it can be very attractive to have a testamentary trust in place. And then when in Karen's passing, another trustee, e.g. Perpetual, funny about that, becomes the trustee of the trust, and we look after Max and Jane. Now, just from a tax point of view, so that's asset protection. So those assets of John and Jenny at the outset are now protected for the grandchildren evermore, or while the money lasts, of course. But also, if we had distributed the estate directly to David, the son, and Karen, the daughter, and they invest that at a generous rate of 5%. If you can get 5% in a term deposit nowadays, you're doing very, very well. But nevertheless, the tax on that sort of distribution, without going through the numbers, are at about $26,000 in tax by leaving John and Jenny's money directly to the kids. Put it through a testamentary trust where you have control of distributing the trust assets to those on the lower marginal tax rates, means that the income can go out to the kids, they get the benefit of the tax-free threshold, and they've saved $26,000 odd in tax by having a testamentary trust. A little bit more complex, you've got an interposed trust in place, but from an estate planning message, that's asset protection, minimised trust. Many of you in the room may already have testamentary trust, but that's effectively what you're trying to achieve. Just concluding on dealing with superannuation, because I think that's an important part, because we often get asked by people about leaving money to charities. Can I leave my superannuation to a charity? Can I leave it to Garvan? The issue is, with superannuation, the way in which this works is that, as I said earlier, super is a non-estate asset. It is not dealt with through your estate unless you specifically direct your super to your estate. Super can go directly to your beneficiaries if they qualify under superannuation legislation. And the types of beneficiaries that can directly receive your superannuation monies directly from the fund without going through the estate is your spouse, a child of any age, somebody who is financially dependent upon you, or somebody in an interdependency relationship. So you can see the issue here is that if you wanted to leave money to a sibling, brother or sister, not financially dependent upon you, a parent, for example, and we often see children when they first leave school or finish university. Of course, they start their first job and they're asked to join a super fund. The super fund says, in the event of your death, where do you want your death benefit to be paid? And they go, Mum and Dad. It's not even worth the paper it's written on. Mum and Dad aren't beneficiaries, right? Not worth the paper it's written on. What you can do, as I said, is direct it to your estate, leave it to your legal personal representative, and then deal with it through your will. So basically, if there are no cis-dependents, like i.e. that child that's just left school, no spouse, no kids, only mum and dad, he has no cis-dependents. A charity, e.g. Garvan, is not a superannuation dependent. You cannot leave it directly from the fund to the charity. You need to advise the trustee to pay your super to your legal personal representative, and then more importantly, make the necessary arrangements in your will, okay? Have a carve out in your will for the treatment of your superannuation assets. That's the most effective way of dealing with it. So, in conclusion, 5 key takeaways. Ensure your estate assets and interests, including your super death benefits, go to the right persons and charities in a timely manner. Determine the most tax-effective way to distribute your estate assets and interests. You really do want to protect your assets and interests, as we saw in that very simple example of not ending up in the wrong hands at the end of the day. Planning to take charge of your affairs in the event that you lose capacity, regardless of age. An enduring power of attorney is always useful to have to you. And we always recommend to review your estate plan every 5 years, just to make sure it's up to date and there's no unexpected, unintended consequences. Don't leave it to chance. And that's the message I have. That's my disclaimer to say you can now disregard everything I've said. So thank you.